Hi there, I hope you're doing great. My name is Tiaba Conrad, and once again today I'll be taking you through another topic known as execution proceedings against government. So, before we start on our discussion today, I encourage you to subscribe to my channel. Just make sure you click down on the subscription button and then also turn on your notification so that you're able to receive um, a message on every video that I release on our legal classes. So let's proceed. And like I said earlier, we're going to look at execution proceedings against government. This is simply a continuation under the topic of execution. However, there is a different legal framework within which execution against government is carried out, and the laws and the procedures are different from those that we looked at earlier on execution against private individuals and entities. So, ladies and gentlemen, in this video, we are going to basically look at the following areas. We are going to look at the law on execution against the government. We will also discuss the mode by which government can execute against individuals or other entities. We are also going to look at whether execution against government can be carried out anyway. Can you execute against government? We are going to be discussing that element. Then we are also going to look at the timelines of execution against the government. Then we are also going to look in this discussion, we'll be looking at whether a suit can be commenced against government by way of summary procedure. We will also be looking at the procedure of executing against government. We will unlock it and unpack it in material detail. We will also be looking at execution against the local government. Can you execute against the local government? Then finally, we'll be looking at the documents necessary in the premises that you will need to carry on with the execution and the procedure. So, ladies and gentlemen, let us commence immediately with looking at the law on execution against and by the government. And here specifically, we are looking at the central government. So the authority, basically, the law that governs execution against government is the Government Proceedings Act, Cap 77. So anything pertaining to execution against government will be found under that legal regime. So I invite you, first of all, to interest yourself in Section 19 of the Government Proceedings Act, and that section in particular provides that it provides for satisfaction of orders against the government. Also of interest, let's proceed and we look at the mode by which government can execute. Remember, we said that government can execute as well. Just like you may desire to execute against government, it's also possible that a judgment can be entered in favor of government and government can execute against you. So let's look at the mode of execution by government. That mode basically is under the law. Look at Section 20, subsection 1 of the Government Proceedings Act, and that section provides that any execution by government shall be carried out as any execution as if it was executing against a private persons, okay? Or execution, the same way you carry out an execution against a private person is the same way government will and can also carry out the same execution. Let's now proceed and we look at whether execution against government can be carried out. Is it possible that you can have a judgment in your favor and then you proceed to execute against the central government? The position of the law is very clear. I invite you to look at Rule 15 of the Government Proceedings Civil Procedure Rules. When you look at those rules and you read under there, they expressly exclude the applicability of Order 22 and Order 23 on execution of decrees, that's one, and orders and attachment of dates. So you cannot execute a decree against government, orders or to attach money of the central government, for example, from the consolidated fund, among others. That order, when you read it in material detail, it also excludes Order 42 on appointment of receivers in matters relating to government. So you cannot appoint, you cannot execute by way of appointing a receiver against government. So the law expressly prohibits that. Let's now proceed and we look at the timelines, okay? The timelines within which execution against government can be commenced. I invite you to look at Section 19 of the Civil Procedure Act. That section is clear, and execution proceedings against government can commence after a grace period of 21 days from the date of the decree, or at any time after costs have been taxed. So you can only commence against government after the expiration of 21 days. That is important to note. Let's now proceed and we look at whether a suit can be commenced against government by way of summary procedure. Remember, we have been looking at summary procedure under Order 36. Is it possible, okay, that if you fall within the ambits or the parameters of Order 16, there's a liquidated demand, maybe even the matter pertains to trespass to land or misdemeanor profits as seen under Order 36. Is it possible that you can proceed by way of summary procedure against government? That is what we are going to briefly look at. The position of the law is very clear. I invite you to look at Rule 17, Sub-Rule 2 of the Government Proceedings Civil Procedure Rules. When you read those rules, they prohibit you to proceed by way of summary procedure against government. And government cannot suffer liability for a suit commenced by way of summary procedure under Order 36. However, this rule, it's important to note that it should be read together with the case of Uganda National Roads Authority versus Vivo Energy Uganda. That case is authoritative on that aspect. In that case, the citation of that case is HCM Appeal number 209 of 2014. You look at the judgment of Justice B. Kainamura. In that case, court held that the discrimination between execution, the discrimination pertaining to execution between private individuals and government was no longer applicable. Okay, so when you're discussing Rule 17, Sub-Rule 2, it's important to also bring to life the decision in UNRA versus Vivo Energy. But however, it is always a question of which law supersedes the other. Are they the rules that supersede the decision of court? And that is it's always very prudent for you to know the law, but also discuss the contrasting view under case law. So let's proceed and we look at the procedure of execution, or the procedure of executing against government. Whereas we said that you cannot proceed to execute against government, but in the event that you are successful as a judgment creditor, there are certain procedures, or there is a procedure that you can take against government to ensure that you realize the fruits of your judgment. And therefore, we are going to look at the procedure. What procedure would you take to ensure, as a judgment creditor, that you realize the fruits of your judgment? The procedure is as follows. The first step is you extract a decree. That is very important. The second step is you draft a bill of costs and cause it to be fixed for hearing and taxed inter partes. And finally, obtain a certificate of taxation. That is the second step. The third step is that you make an application to the Registrar for a certificate of order. Authority, look at Section 19 of the Government Proceedings Act and Rule 14 Sub-Rule 1 of the Government Proceedings Civil Procedure Rules. They are authoritative on that. Then also important to note, a certificate of order only issued on certification that 21 days have lapsed from the decree. Remember, we already talked about the 21 days, that you can only proceed to execute against government after the 21 days have elapsed. So again, this aspect comes up in the procedure, meaning that the certification of order would only be given after the 21 days have elapsed. The fourth step is as follows. You then proceed to serve the decree together with a certificate of order to the Attorney General under a covering letter providing the account number of the beneficiary, i.e. the creditor. Authority, look at section 19 of the Government Proceedings Act, Cap 77. You then proceed to the fifth step. The fifth step is that the Attorney General will then transmit the certificate of order to the Treasury Officer of Accounts to appropriate payments. After that, the next step is where the same is not affected within a reasonable time, meaning that if that is not done within a reasonable time, the creditor may take out mandamus proceedings against such public officers in the High Court. Authority, look at section 37 and section 38 of the Judicature Act, Cap 13. So you only take out these mandamus proceedings in the event that the same has not been given to you. If it's your money, it has not been given to you after reasonable time, you can then take out what we call mandamus proceedings. Now, if that officer still fails, okay, even when you take out mandamus proceedings to compel them to execute such orders, but such an officer still fails, he or she will be held in contempt of court. And of course, an order can be issued out to arrest and detain such an officer. So, ladies and gentlemen, let us now proceed to look at execution against local government. Is it possible that you can execute against the local government? This is what we are going to look at. So, what is the position of the law on execution against a local government? Is it also the position that just like the central government, you cannot execute against local government? The answer is both yes and no. On execution against a local government, and I invite you to look at section 6, subsection 1 of the Local Governments Act, Cap 243. When you look at that section, the section provides that local governments are body corporates with perpetual succession and may so be sued in their own name. So you can sue local government individually or as separate entities from the central government. As such, if you also proceed to look at section 6, subsection 2 of the same law, that section bars the following actions. It prevents the following actions. 1, execution, attachment, or process in such a nature for enforcing payment against fixed assets and statutory transfers. So for fixed assets of the local government and statutory transfers, you cannot execute or attach them. Fixed assets, I emphasize this, fixed assets and statutory transfers of the local government cannot be executed or attached. But also that section also goes on to state that execution or attachment of any other property or on any other property before a period of 6 months after the date of judgment or order or decree is also prohibited. So if you must execute or attach any property of the local government, you have to wait for the expiration of 6 months. So the law is express. It prohibits attachment and execution against the local government. However, ladies and gentlemen, there is a rider. Not in all scenarios or cases that you cannot attach property of the local government. There are situations where you can proceed to execute and attach property of the central government. And the principle here is where property is bought by the local government, in its own right, using its own money, then such can be liable to attachment. However, where the central government purchases for the local government, then such property cannot be liable to attachment. That is the principle. For as long as the property has been brought by that local government on its own money, then it can actually be attached. But if such property has been purchased from money solicited from the consolidated fund or from central government, then the same cannot be attached. Ladies and gentlemen, let's then proceed to look at the documents. What are the documents that are necessary in the premises for execution to commence? As I always emphasize, please ensure that you're able to draft these documents. I cannot overemphasize the importance of knowing how to draft these documents. However, I will briefly outline for you the documents that are necessary. Document number 1 is a decree. You need to have a decree. Document number 2 is an application for certificate of order, and that application is by way of notice of motion supported by an affidavit. Authority, look at Order 52, Rule 1 of the Civil Procedure Rules. The other document is a certificate of order. Please ensure that you know how to draft these documents. So, in summary, ladies and gentlemen, that is the law and the principles and the cases governing execution against government. Thank you very much for listening in. Once again, I invite you to subscribe to my channel. Ensure that you subscribe and you also click on the notification bar so that you're always able to get these videos whenever they are released. Thank you very much. May the Lord God bless you in your endeavors. Bye-bye.